Welcome to Just Champions, a podcast by Equitas, which focuses on the prosecution of sexual violence, domestic violence, stalking, and trafficking from the perspective of the prosecutors who handle these cases, the allied professionals with whom they collaborate, and the victims and communities that they serve. I'm Jennifer Long, the CEO and co-founder of Equitas, and a former prosecutor specializing in adult and child sexual abuse, intimate partner violence, stalking, and sexual exploitation. This is the inaugural season of Just Champions, where we will explore the ways prosecutors influence justice and safety through the lens of our guests who impacted safety and justice for victims and their communities in ways you may not expect. In this episode, I am joined by Deb Tuerkheimer, who's a former prosecutor in the Manhattan DA's office, where she specialized in domestic and sexual violence. Currently, Deb is the class of 1940 research professor of law at Northwestern University's Pritzker School of Law. She writes and teaches in the area of evidence, feminist legal theory, and criminal law. In addition to several articles on domestic and sexual violence, Deb has published several books, including Credible, Why We Doubt Accusers and Protect Abusers. Hi, Deb. Thank you so much for joining me today in this great conversation about your career and as a prosecutor and beyond.
Oh, I'm so happy to be speaking with you. Thanks for having me.
Thank you so much. And as I know you and I know each other, but then when I always sit down and start to talk to people, I realize how much of their life I think I know, but I don't really know. Obviously, I got to meet you through your current role as a professor at Northwestern University Law School, and I know that you were a prosecutor in Manhattan, but people listening really don't know the arc of your career. So could you talk a little bit about your career?
Sure, I'd be happy to. I actually went to the Manhattan DA's office for the first time during law school, one of my summers, and I was drawn to the office because of its reputation, particularly its reputation for prosecuting sex crimes. And so as a law student thinking about some kind of public interest career, I knew that gender-based violence was something I cared deeply about. And I thought I would see what it was like to be in a prosecutor's office dealing with that issue. Obviously, there are lots of different ways to help survivors and to work around gender-based violence, but I wanted to see what prosecution was like. So I spent part of a summer in the office. I loved it and ended up going back to the Manhattan DA's office pretty soon after law school. I did a clerkship in Alaska. I clerked for the Alaska Supreme Court, and then went to the Manhattan DA's office. I was in the office, and we can talk more about what I did there, but I was there for 5 years. And then I went into academia, and I've been a law professor ever since at various law schools. So my career has essentially been prosecutor to law professor.
So you were drawn to it because of its reputation into Manhattan. So did you always know that you wanted to be a prosecutor? How did that form?
Yeah, I don't think I knew I wanted to be a prosecutor, but I knew that I wanted to work with victims, survivors, and I also knew that I wanted to be in an environment that was fast-paced, and I wanted to feel like I was doing work that was meaningful. And so, part of it was getting into the office and realizing that it really did resonate with those desires. But I also loved being in court, and I loved the sort of diversity of people that I came into contact with, and I loved not just trying cases, but standing up on cases. And I frankly, it sounds, I'm sure, very corny to say this, but I think doing justice and having that be the mandate was a really nice fit for what I wanted to do.
I don't think that's corny, but I'm biased, of course. And a lot of offices are set up differently, and you sort of, teed this up when you were describing your time at the Manhattan DA's office. So I know and people on the call may know that when you start in an office, you are not given these cases, sexual violence, domestic violence, stalking, human trafficking, or you shouldn't be given them. As the first cases you get, although actually you and I both know we work with small jurisdictions, and sometimes truly that is what happens because that's the needs.
Yeah.
What led you to focus on these crimes, and what led you to be able to focus on them at the Manhattan DA's office?
So I want to be clear that I left the Manhattan DA's office decades ago. I'm old now, I suppose, but I was in the
As
office
we all
until
are.
2002, right? So it may be different from what I'm about to describe. So with that caveat, I will tell you that I started in the office and I got domestic violence cases from the get-go. Misdemeanor domestic violence cases were handled by all of the assistant district attorneys. For me, that was, absolutely wonderful. It was exactly why I was in the office. It was why I wanted to be a prosecutor. And so I was very fortunate from my perspective that I was able to work the cases that I wanted to be working, not exclusively. I handled all kinds of misdemeanors when I started. We all did. But I had those cases that felt like they were a reminder of why I came. And so I, kept doing the domestic violence cases. I was in a general trial bureau.
Okay.
After about a year of misdemeanors, we were given felony cases, and domestic violence was part of that caseload for me. And then as soon as I was able to specialize, I did so.
Okay.
And I, then worked exclusively on domestic violence and child abuse cases. I was in it was called the Family Violence Bureau at the time. And I did, again, domestic violence, child abuse, and many of those cases were also sex crimes cases.
How did you prepare? How were you prepared? So, law school, and maybe again, I know we were both in law school, maybe about the same time, it sounds like, and there were some clinics, but can you talk a little bit about? We definitely had an interest before law school, how you prepared or how you became prepared, how Manhattan DA's office prepared you to handle these kind of cases.
Sure. I mean, I think it's looking back, remarkable, that we were all handling these cases so quickly. I give a lot of credit to the training program that Manhattan had at the time, and I assume continues to do well. It was intense. It was at the very beginning, it was all we were doing was training and learning the logistics of cases and how they were processed through the system, more about New York law, New York evidence law, trial advocacy, and then of course on the job we had very, very close supervision, and there's a lot of learning on the job. And I think that it took a while for all of us to feel like we had our sea legs, so to speak, and that's good. I mean, if you're feeling confident at the very beginning, something is wrong, and there's way too much hubris there, I think, because it's daunting, and it's a lot of responsibility, a lot of power, a lot of discretion, and I think people should be feeling very daunted at the prospect.
Did you get, and no, everything you're saying speaks so true. And it's, I'm finding myself going back to that time of a lot of uncertainty, right? Because the system is uncertain. There's so much going on. And one of the things I remember, we were really lucky. We had fantastic in the office, great victim witness and individuals who worked specifically on these crimes to help educate us as well as our peers, and then outside community advocates. Can you talk about, I know that the system was like for you, what your experience was with how those outside partners helped, or inside partners?
Yeah, I think both. We had both resources, both kinds of resources available to us in Manhattan, and it was enormously valuable to be able to learn from folks who worked with populations, these special victims populations, whose needs are different. And again, especially because those were the cases I knew I wanted to focus on, I, kind of soaked it all up and tried to learn everything I possibly could from people who knew so much more than I did about how this all worked on the ground. After several years in the office, I became the domestic violence supervisor for all of the misdemeanors that come through Manhattan. And, and in that capacity, I was also able to develop relationships and build on relationships with those partners that you're describing.
Mhm.
And I think that was really useful for our assistants to get not only the perspective in-house, but to hear from people working outside the community with victims, with survivors, to understand those needs in a more detailed way.
No, absolutely. And so, I mean, you've been very humble, and we're going to talk about your career now. But I'm still going to stay in. I'm going to stay in the courtroom for a little bit. But of course, you didn't mention that you are an author of very many, and there's amazing academic books, and then there are academic books also that speak to so many of the practical issues that we're all facing, and particularly in sexual violence. And you've managed to create these really substantive, well-cited, incredible, really easy reads. I mean, you're like, want to read these books, and they're helpful. And
Oh.
I imagine that your time in the in the trenches might have led you to this. So, if you could talk about, I mean, when I think about these cases and I'm thinking specifically about sexual violence, but intimate partner violence, stalking, exploitation, they all move together. The kinds of legal issues that you faced, handling the cases, and how you handled them.
Yeah. I, I mean, I think that everything that I've written and that I continue to write in some way, shape, or form goes back to my time as a prosecutor. Those intuitions, those insights, those passions, those were all formed in those years when I was working every day with victims and seeing the way the system did and did not work to advance justice for those individuals. And so, I would say that a big part of the reason I became a law professor and decided to leave, the prosecutor's office to go to an academic setting is to be able to have the luxury of time to write and to pull back without a caseload, a crushing caseload, and to be able to think about how the system could respond more effectively to these particular crimes. And I should say too, to be able to teach, I mean, the classes that I teach are, criminal law and evidence, and I teach feminist jurisprudence, and I teach a reproductive justice class. But, those classes too, I think are helpful for people who are not going to practice criminal law exclusively. But I do want people to come out of my classes feeling like they have a really good sense of how the real world works, and that this is not just an academic exercise. This is not just theoretical. These are real people's lives who are impacted every day by these laws and their implementation. So I don't know if that answers your question, but I do want to be very clear that there, for me, has been the closest connection possible between my time as a prosecutor and what I've been doing ever since.
Yeah, no, and you have, and I think I mean, one of the most notable things that I know that you've written on, although there have been many, is on credibility. And of course, as prosecutors and in these cases, one of the things we talk about when we try to do community education, both as prosecutors and it's sometimes in our role now at Equitas, is explaining to people who may not be as, embedded in these crimes and enmeshed in them all the time, how victims of these crimes face almost a dual victimization because they're victimized and abused. And then the default is that they're not credible. And so it's right from the beginning, they're starting from a place of trying to convince people that something happened to them and that they're worthy of people's belief in perhaps the system. And you've written about that. And I think about the rules of evidence, again, these things that when we're in law school may seem very theoretical, that have a very practical impact and impact that. And I was wondering if you had some rules of evidence you want to talk about, or some things that you think really have that impact that you just talked about.
Yeah, I mean, so on the first point about credibility, it's something as a prosecutor I thought about, of course, every day. It's really one of the main tasks of a prosecutor is to evaluate credibility at the outset and in trying to decide whether to pursue a case, and then to build a case and to think about how to persuade, this jury beyond a reasonable doubt, that your witness and part of that is convincing the trier of fact that you have a credible witness. So credibility sort of frames about everything that we do. And then I, started to think about all of the ways that the law kind of bakes in what I call credibility discounting. And so for victims who come forward for accusers is how I frame it in the book. That's called Credible: Why We Doubt Accusers and Protect Abusers. Well, accusers have the deck stacked against them for all sorts of reasons that are not idiosyncratic, right? And so the book tries to look at law and culture. And to the point about law, think about the jury instructions that people are given. Use your common sense when you evaluate the credibility of witnesses. And that's something that jurors across the country are told. And I think it's so interesting because common sense doesn't work when it comes to evaluating the credibility of sexual assault survivors. And that's just sort of one entry into this kind of bigger question of how do we judge credibility? And I think in writing the book, I was really conscious of not wanting to beat up on prosecutors because the point that I try to make is that this credibility discounting is something that happens across the board. Yes, it's police officers. Yes, it's prosecutors. Yes, it's judges and juries, but it's also lay people. It's also the college roommate, and it's also the mom, and it's also the coworker, people who are well-intentioned and want to do right and yet are sort of steeped in these misconceptions and these biases. And so I think again, my time as a prosecutor informed the way I approach this subject. Yeah, so that's one example. Rules of evidence that I'll just quickly mention that I love to talk about and think about and write about. Those dealing with experts, because I think expert witnesses on common behaviors of victims is a really interesting and important topic, and ways in which experts can testify without pathologizing victims and making their behavior part of a syndrome, so to speak. That's something that you and I, Jennifer, have talked a lot about, and you've been hugely helpful in my thinking, and your own writing in this area is so important. And then there are character rules, and there's the confrontation clause and sort of hearsay rules. So there's so much if you care about these kinds of cases, these kinds of victims and survivors. The law is just rich in providing this fodder for analysis.
No, it definitely, and it's so interesting too. I mean, when I think about these rules of evidence that you just talked about and how uniquely they apply in our case, obviously they apply in other cases, but how uniquely they apply, and even at the highest levels of appeal, they've been raised, and I think in a lot of ways have helped educate the public about not only these crimes, but about proper balancing of the Constitution and victims' rights and due process. But it also amazes me, and you and I have experienced this, of the hypocrisy when we are, analyzing these laws. And I think specifically some of the conversations we've been a part of around other acts evidence, which I know you and I both, I mean, I think that's an area where we understand it's appealed and, want to be very circumspect, certainly not want to be painting defendants in one case for any things that they've done in the past, but also being acutely aware of how perpetrators learn from other crimes. But you have this analysis and this conversation about the prejudice of other crimes. And then when we sit and talk about rape shield, all of a sudden everything's backwards. And the people who are worried about prejudice, all of a sudden these non-criminal, totally normal acts that seem to have nothing to do with consent, it should be an open floodgate. And I wonder if you could talk a little bit about your experience with other acts evidence, rape shield, either or, both.
Sure. Sure. I guess maybe I'll talk about the rape shield. I wrote a law review article years ago now called "Judging Sex," and the article is about an exception to the rape shield rule that in many jurisdictions allows judges to admit evidence of a victim's so-called pattern of sexual conduct if that behavior seems somehow to be unusual, right? Or not normal in quotes. And that's where the name judging sex comes from, right? Because it really gets at what these judges think about how women often
Yeah.
ought to be behaving sexually. And, what are the normative behaviors that fall into this category of acceptable female sexuality. And so it was, this opportunity to look at the case law and to see what kinds of sexual conduct, consensual sexual conduct, were coming in under this so-called pattern exception. And so that's, a way that judges were truly constructing like deviant female sexuality under the guise of rape shield rulings.
And to be clear, this is that it would be relevant to consent, to credibility, to both, to.
Absolutely. Absolutely. And this is, several years ago, I don't remember the date of the publication, but this is, contemporary, right? This wasn't just a retrospective of sort of what happened in the dark ages. This is sort of how rape shield rulings are happening today under this fairly little noticed exception. And so, it's just really interesting to me the ways in which these modes of thinking that might seem on the surface to be archaic and obsolete and no longer operable maintain a hold, and they may change and may become sort of more acceptable or framed in ways that are softer, let's just say. But still today they kind of affect the ways in which these laws are applied and the ways in which outside of law female sexuality in this case is understood.
Yeah, and I think this goes back to something really important you said about that term common sense that we see in the jury instructions, either written or just said. And what does that really mean? What has informed the common sense, and how much of the recent research is absent from this determination of what your common sense tells you and what your experience has told you?
Yeah, and this is not at all to deny that progress has been made. I mean, as a result of the amazing efforts of law reformers and particularly feminist law reformers, I do think that we are moving forward. And at the same time, I think it's really important not to overstate the extent of that progress or to neglect the ways in which we still have a way to go.
Yeah, we need to be vigilant. And it's true. Sometimes I think you're right. Sometimes we may think, even as a field, okay, I mean, you talked about expert testimony. Okay, that's accepted. We understand it's been written about for many decades. And so this should be something that's not only the admissibility of the expert testimony, but the fact that there is this range of behavior is understood. And yet, you're right. If we're not vigilant, we miss that people have that. And can you talk just a little bit more, because you have written about that, some of the behaviors that as a prosecutor you found unfairly being used by the defense, or unfairly being, you were concerned that a jury or other fact finder would use against the victim, and how you tried to counter that?
Yeah. Sure. And I should say that because the book was published just a couple years ago, I feel confident in seeing that this is still happening, right? Because it would be easy for someone listening to this conversation to say that my experience is now so dated that what I'm describing, is not a problem anymore. And I want to be clear that in the book, the examples that I give are from more recent years. And so the behaviors are kind of in the lead up to the assault, during the assault, and after the assault. Those are the ways that I would categorize. In the lead up is, the drinking, right? So what was she drinking? How much was she drinking? What kind of flirtatious behaviors or sort of welcoming behaviors was she exhibiting? Maybe even what she was wearing. And I know that might sound surprising to people, but still the sort of the question of what she was wearing is on the
Right.
mind.
They sneak it in there, or they just sneak it in there. Right.
That's right. That's right. During is the what people will see as a failure to resist enough. And that can be, failure to resist physically, or maybe not to say the right words, but not to do enough, not to scream, not to run away, not to have the right reaction in the moment to stave off the assault.
Mhm.
And then afterwards, the failure to report immediately, the failure to seek immediate medical attention, to get the rape kit, to promptly report, to law enforcement, to have the right emotional reaction to it all. All of these things come up, and they go into this determination of credibility. If everything isn't just right, then the victim is more likely to be perceived as someone who's not telling the truth, or someone who's to blame for what happened, or someone whose violation doesn't matter.
No, and I think that's such an excellent point because you talk about resistance and the need to talk about it. And it's true, right? Even in jurisdictions where the law explicitly doesn't have a resistance requirement, it's always there in the background, right? Because I love how I can't even remember, you just said it a few minutes ago about how all that evidence is taken in, that somehow a victim is discredited if they've made a decision to make. And I know that there's, on expert testimony, there's a whole range of why individuals may, behave the way they do. Some of it is physiological, and some of it can be experiential and based on your decision making, that is what is going to keep you safe, or that is what is you're going to need to do to get through something. And that would be, one would think that's common sense, but I think, as you've just shown, it's not common sense, and it is constantly used regardless of what what the law might have explicitly said.
Absolutely. Absolutely. And, I think one that maybe I didn't mention is the kind of continuing contact with the perpetrator.
Yes.
And that's a big one. And, experts have testified in big name cases that this is such a commonplace reaction, right? So it's counterintuitive to many, and it doesn't fall within, common sense, perhaps. And yet it is, I don't know if an expert would use this word, typical, right? But it's very commonplace.
Right. No, absolutely. And lots of different, and sometimes I'm sure in your experience and your experience, I mean, in New York, you had a different experience because you were allowed to use experts before we were. I practiced in Pennsylvania, and we were really just relying on our argument, but just trying to. So sometimes you'd have a victim who could explain some things of why they went back. Sometimes it was obvious from the facts. If someone's within a family, you have a child, or, even I would say an intimate partner violence victim, one would think that could be more understandable, but the public still doesn't understand that some in ways that I feel like we should at this point. But you're right. These are things that people have an expectation, right or wrong, and they need to be addressed just to keep it level, keep the playing field level so that the facts really can be assessed accurately.
Yeah. And to make the jury care about this person, right? Because you and I both know that it's not enough to sort of have the jurors believe that this happened, right? They also have to care enough about it happening to come back with that conviction. And all of this sort of goes to how is this witness appearing on the stand? How is she being portrayed? And it's so easy. We have these blame shifting impulses and these instincts to sort of care more about certain people than others. And so I think that this is also under this broader conception of credibility that I think is helpful. It's not just about what happened, it's about who's to blame for what happened and do we care about what happened?
And do we care about them? Exactly. So sometimes I think every profession thinks, okay, this other profession, this is really green grass. Like this is where it's easier. And academia, I would think in the criminal law, you have this experience and you're able to sort of take everything you learn being on the ground and write about it and talk about it. And I guess and that, but obviously I realize it's also difficult because you're in another, you're in another community now and have all of the same dynamics that we have when we're on the ground with defense and prosecution. But I'm wondering if you feel like your career, your time as a prosecutor helped you in academia. I know you talked a little bit about the classroom, and I'd love to hear more about that, or maybe with peers and other ways that that you've been able to
Yeah.
use that experience.
Oh, one thing I say to my students on the first day of class, and this is true in my criminal law class and in my evidence class, those are both very large lecture classes, is that it's so essential not to lose sight of the fact that every case we read has real people who've suffered. And I am talking about victims, and I'm talking about the defendant in the case who often was sentenced to prison. And that these are people whose suffering can so easily be overlooked, particularly as you go through law school and you read case after case, and it can seem so sterile and it can seem so academic. And that what I really hope is that as they go through my class and beyond, and certainly into practice, that they never lose that sense of humanity and that sense of compassion for people, because these are sad cases for the most part, particularly the subjects that I teach. They are sad cases. And I think that's just one example of the ways in which being informed by my time and practice is translated to my role now as teacher.
And that's it is sad, right? Because no matter how egregious the crime, no matter how great the harm, and how just the outcome, to include incarceration, if that's, those are the cases you're dealing with, it is a tragic moment around. I mean, defendants will be there with their families, and you just think about a life that led to causing such harm, right?
Yeah. I'm often asked by my students how I, kind of did that job as a prosecutor, because they find the cases sad, maybe in part because I've sort of, insisted that we see it, right? That
Yes.
we become, kind of hardened, that we don't develop these calluses that make it more difficult for us to experience the pain. And so, a natural question then is, well, how did you do that job then? How did you work and I will say that there is a difference when your job is to help.
Yeah.
Is to help a situation. You're never going to make it so that it was as if it never happened. You can't do that. But you can pursue justice and you can make a difference in the life of the victim and even sometimes the defendant, right? Being a prosecutor who cares about fairness, who cares about justice, that's really important on both sides of our adversarial system. For the defendant to have a prosecutor who's honest, who has integrity, who isn't just looking to sort of put a notch in the belt. And I think being able to do right by the case and to focus on that is clarifying, and it's very focusing, and you're doing it in the midst of watching someone be very, very resilient in their own life. So there's, in that way, you asked about what's harder about the job that I do now. It's as a prosecutor, you have a lot of agency. And when
Right.
you're reading about cases in a casebook, you don't have that agency.
Right. And you're right. You have the opportunity to be a part of someone's life, even if it's just to be the person who listened, to help elevate their voice and to be a part of a horrific harm, trying to repair it in some way.
Yeah.
And that's, I mean, so of course you anticipated that was my question, like how do prosecutors impact the experience? And I think you just laid that out so brilliantly. Um, I have a question about just, talking about these case decisions, and that, of course, when we're reading them as law students or as lawyers, they become then the words on a page, and all the transcripts and the files and the discovery. That's not something that we're really having. We're seeing this outcome. Uh, how do you think, or have you seen any cases or any appeals that you might have been a part of, either written or amicus, where that really brought a victim's voice into the process when it's being up at the appellate level? Um, you had talked so much, all of the issues you raised, like confrontation. I think about all the cases that came up, Crawford, Davis, some of the forfeiture cases, these cases that some of them dealing with domestic violence specifically. But I don't know, have you like ever reviewed cases and noticed a place where the appellate lawyers really help bring the victim's voice in, even when it's on a specific point of law that's coming up on appeal?
Hmm. That's a really interesting question, because I do think that the system is, almost built as you get higher up in the appellate process to kind of put those, voices farther and farther in the backdrop. A lot of, I think, what we're seeing with some of these high profile cases are victims finding ways to amplify their voices outside of the legal process.
Mhm.
But I do think that some appellate judges, and I'm thinking about the Wisconsin Supreme Court, and I'm not going to remember the case, but there was a beautiful dissent by one of the justices that was what I would call very survivor centered. And so I do think that there are ways that appellate judges can manage to keep that perspective, but it's hard, right? You've got to be so conscious of it and deliberate and mindful about doing it, because if not, it all just becomes so removed from the actual lives that are impacted.
Right. Right, exactly. And all of these cases, they all have an impact not only on the direct life of the case that's being appealed or litigated, but on countless of other victims and defendants down the line who are going to be bound by it. Uh, so in teaching your students, I don't know if you follow their careers or know how many of them go into prosecution or if they talk to you about it. Um, do you encourage people to go into prosecution, and why, your law students?
Hmm. Well, I mean, my students know that I loved my job. My students know that I'm very proud of the work that I did as a prosecutor, and that the cases that I handled continue to mean the world to me. I carry the stories of the victims I worked with. And I will always. And so they know that about me. And I think that, even beyond what I tell them about their own careers or the advice that I give, they have an example before them of someone who was very satisfied with the practice of law that I did. Um, you know, I think for the right kind of person, prosecution is the most rewarding possible legal career. I think if the fit is there, if the person is committed to doing the job well, there's just nothing that makes you feel as a lawyer like you're having more of an impact on people's lives. And the practice on top of that is stimulating. It's fast paced. It has you thinking on your feet in ways that I think very few lawyers actually get to do. There's not a lot of tedium or monotony. I mean, it really is a dream job, again, for the right kind of person. So I think that answers your question about what, my students hear when they want to talk to me about a path in prosecution. And unsurprisingly, perhaps many of my students, many of my best students have gone on to happy careers in prosecutors' offices.
Well, I can't think of a better way to end it. I mean, I I hope that listeners understand that they have gotten the benefit of listening to someone today who really was able to move through every step of the prosecution practice and handling these cases, and every piece that you learn through every interaction. It's so clear through your writing, which I've been lucky enough to read a lot of it, not all of it, and through the work that you do today to include teaching your students. So I'm so glad I got a chance to talk with you today and hear about your arc. As a
Mm,
prosecutor the rest of your career. And I thank you so much for all you keep doing for the field to help move us to the
mm.
place we should be.
Well, thank you so much for this conversation. I've enjoyed it so much, and just getting to talk to you, and also to know that the work that you're doing is so critical. And, you've been an early reader on so many of the things that I've written. I benefit so much from your wisdom and your expertise, and people who work with you and with Equitas are so fortunate.
Oh, thanks so much, Deb. Thank you so much. And I think you're headed into a new semester. So good luck with that.
Thank you very much.
Thank you. Thank you.